Morning, everyone. You ready to go?
Yes, Your Honor. Thank you from the jail.
All right. So, as always, I've already read through each one of these files, so I'm familiar with the probable cause sheet, as well as the court assessment notes, risk assessment, and other information in the file. So obviously, I'm interested in the factors on bail, community safety, and appearances. So the first individual we have this morning is Mr. Burr. Tryvin, Travin, I think it is, Burr.
Yes, Your Honor. Your Honor, may we take Mr. Greenleaf first, as I believe there is a percipient witness online, as well as this is a continued matter. Will the court allow, please?
Absolutely.
Thank you.
I have Mr. Greenleaf right here. Looks like we have two for Mr. Greenleaf, one of which is a citation. So let's do the criminal case first. All right, is the DA ready to proceed?
Yes, Your Honor. So Your Honor, with Mr. Greenleaf, we are asking for $50,000 bail, pretrial supervision, no weapons. We have Miss Elliott on the phone. I do believe that she is not going to be asking for a no contact order. That she has indicated that the story is unfolded differently than what she initially told law enforcement. However, we are asking for, as a state, a no contact order pursuant to any sort of release order. The defendant has criminal history going back to 2000. He had a gross misdemeanor conviction for taking a vehicle without consent here in the second, as well as a possession of drug paraphernalia. He had a possession of drug paraphernalia conviction in 2002, as well as a domestic battery arrest. There was a Reno Municipal Court that I can't find a disposition for. He had a 2003 felony conviction for robbery where he had his probation revoked here in the second judicial. He had a 2004 misdemeanor conviction for battery, which is down from battery with a deadly weapon. Had a 2007 misdemeanor arrest for battery in Carson City with no disposition. Then in 2008, he had a misdemeanor conviction for domestic battery in Carson, a 2009 misdemeanor conviction for DUI in Carson, as well as a misdemeanor conviction for domestic battery in Sparks Municipal Court. Then in 2010, he had a domestic battery second conviction in Carson City. Then in 2011, he had a felony conviction for domestic violence third in the first judicial. And then more recently in 2023, he had a gross misdemeanor conviction for violating a stalking or harassment TPO here in the second judicial. So this is an individual with quite a bit of violence in his past, concerningly domestic violence, as well as prior felony convictions, one for robbery and then the domestic violence conviction. Understanding that the victim is likely to indicate that facts were not essentially as they were initially reported. It is still a extremely concerning case with what was set forth in the probable cause sheet as to the statements then, and based upon those allegations, the lengthy history of violence, we believe that this defendant is a risk to the community, risk to reoffend, risk to this victim specifically, and also that the defendant, while again having a similar conviction, this is obviously a prison mandatory case as far as the felony allegations here, and so we believe that poses a risk for him not to appear and do what he should do to take care of the case, and so we would ask for bail.
All right, we have a response?
Certainly, Your Honor. Thank you. I respect what the state believes. It's just not established by clear and convincing evidence when looking at the NPRA. The NPRA is a validated score. Mr. Greenleaf scores a 3 on that scientifically validated evidence-based sheet that is for the prior felony, much of the felony repeated by the state much of the criminal history is remote in time, up to a period of 15 years. For the last 10 years, Mr. Greenleaf has been working at Amtrak Construction. He is successfully working there. He has a residence that we have confirmed with his sister Charlene. The first 4 digits of that are 2885. Given that that is a validated tool where he scores a low risk, that he's been working in the community, the remoteness of time, certainly that NPRA does include the analysis when it comes to clear and convincing, and the state's belief alone is not substantiated by any evidence, particularly where, and Mr. Reichenberg and I could probably spend a long time, not this morning, talking about victim recantation and alleged victimhood and what recantation actually means according to social science, but I think that's far outside the scope of today's hearing. The point is that when we look at remote in time, when we look at the validated tool, when we look at a job, housing, and a victim that is an alleged victim that is saying that she does not believe that this person is a danger to her, I believe it is more appropriate to assume that Miss Elliott knows and that the social science knows than what the state assumes to know based on that remote history. Therefore, I don't believe that they've met their burden under Valdez Jimenez. We would ask for an OR or on his own recognizance release today. Absent questions from the court, I'd submit.
All right. So it's Miss Elliott, correct? Can you hear me, Miss Elliott?
Can you hear me now?
Yes, I can hear you now. Did you want to make a statement, Miss Elliott? Now she's frozen. Still frozen.
Your Honor, while we can wait for a moment for Miss Elliott, I'm also happy to continue this matter out for Miss Elliott to disconnect and reconnect, just in light of how many folk we got here today.
All right, let's give her a little bit of time just for a second here.
Of course, Your Honor.
All right, can you hear me?
There
Miss
you are.
Elliott?
Hi.
Yes, did you want to make a statement?
I just want to say that I don't feel like he's going to come after me or anything like that. I don't feel unsafe. Um, Him and I, in fact, the night before he got arrested, I was there with him. We've been going to church and working on a relationship, and everything's been going really good. And it's been 4 months since the incident happened. They never even called to ask him his side of the story or anything. So it was kind of like a shock. I mean, I don't feel that he's a threat to me at all. And you know, when all this stuff happened, I was doing drugs, and I even told the officer at the hospital that. And you know, that's the whole thing with the story change and all that is but I don't feel like a threat, and I don't want.
All right. All right, so I do appreciate her statement. I think she's told me
Church.
enough, and I've heard from both parties. The problem is the hospital validated marks of strangulation as well as broken ribs. So those don't just happen by themselves. So what I am going to do, given his low risk assessment and the fact that he's fully employed and it's been verified, I just want to confirm for the record, this is going to be a no 10% cash option, correct? Because I didn't hear you ask for it.
Yes, with the category B, domestic battery prior felony, I believe that's pursuant to court order, yes.
All right, so the bail's going to be set at $20,000, no 10% cash option. No contact with Miss Elliott or 1760 Helena Street, number 2. I'm concerned by the facts of this case. He's able to host, he'll be subject to residential confinement. He'll be subject to testing, shall not possess firearms or weapons. He must reside at 2885 Kitski Lane, Unit 48. He'll be subject to monitoring and pretrial service supervision. All right, given the facts of the case and his criminal history, I believe that's appropriate. I have reduced his bail in order to have him an opportunity to bail out, but that will be the conditions. All right, now you want to proceed to the citation?
Sure, Your Honor.
All right, so it looks like we have a failure to slow or move down, given emergency vehicle with emergency lights activated. That's $195. All right, I'm gonna give him 1 day time served and dismiss this case.
Thank you, Your
All
Honor.
right. All right. All right, next is Mr. Burr.
And Your Honor, Mr. Burr waived his appearance today. He does have that pending hold as noted in the PC sheet. I'm prepared to proceed on his behalf.
All right, so do we want to proceed with Mr. Burr? State ready?
Yes, Your Honor. So, Your Honor, in this case, we are asking for $15,150,000 bondable only bail, as well as pretrial supervision, no contact with the co-defendants, which I show as Anthony Johnson, Jason Galindo Cloud, Lillian Da Silva, Justin Moore, and Michaela Meyer. And if the clerk needs those names again, I can message her with those. No contact with the victim, Patrick Moore, and no weapons and pretrial supervision. The defendant scores a 9. The fugitive, so it appears to me that he has 2 warrants, one of which appears to be extraditable. His other warrant, he has what appears to be a juvenile case that's still at warrant out of Beatrice, Nebraska, or Beatrice, sorry. It looks like that's a surrounding states warrant, and we're far enough away that they didn't put a hold on him. And then he has the possession of a stolen vehicle and burglary in Fairfield, California, that appears to be pending from 2025. So obviously concerning case given the violence visited upon Mr. Moore, and doubly concerning given the fact that this young man also has a burglary and property case that's pending in California. So in the state's view, he's a risk not to appear given his out-of-state commitments, as well as the fact that he is here when he has out-of-state commitments, and a risk to this particular victim, and that he should not have contact with those co-defendants given their participation in this. With that, I'd submit it.
All right, do we have a response?
Just briefly, Your Honor, the state has met its burden, I believe, under Valdez-Jimenez pursuant to that 9 on the NPRA score in the pending California case. Therefore, I think that they've met the burden for the monetary bail. Any amount of bail is going to be outside his ability to make. So argument is moot, really, but the 15,000 falls within what used to be the statutory schema, so we would submit.
All right. So I had Michaela Meyer. I had Anthony Johnson. I had, of course, Patrick Moore as a victim. I also had Jacob Cloud and Justin Moore. And I thought there was another individual when I went through the PC sheet.
Yes, Lillian Da Silva. It's Lillyen, and then Da Silva, Dasilva.
Okay. All right, so the facts are concerning in this case. I want to make sure I heard this number right. Did the state say 15,000, no 10% cash option?
Correct, Your Honor.
All right, so 15,000, no 10% cash option. I've already read through the name. Victims shall not possess firearms or weapons. You'll have monitoring with RJC, pretrial services, supervision. All right. Okay. What's that? Might have a spelling wrong on this. Victims, you might want to hold that one out and I'll come back and review it. All right, next individual is going to be Kalani Louie. Hopefully I got that right.
And Your Honor, for the record, I believe it's Hulahi.
Houlihi, okay. All right, stay ready to proceed.
Yes, Your Honor. In this case, we are asking for $20,000 bondable only bail. The defendant has an MPRA score of 10, which shows that, well, he has an arrest in 25 for a probation violation, a misdemeanor conviction for trespass, a misdemeanor conviction for battery, and then a failure to appear after that. Given the allegations of violence here with the weapon, we would ask for pretrial supervision as well as no weapons and no contact with Bradley Ross, the victim in this case. With that, I'd submit.
Was there any history of drug abuse? Did it show up in his risk assessment?
Your Honor,
Not that I could find, Your Honor. He had a probation violation arrest in 25 prior to his conviction, but I couldn't see what was underlying that. So just the trespassing and battery and issues with appearing at court to what I could see.
All right, fair enough. All right, do we have a response?
Your Honor, any monetary bail is going to be outside Mr. Hulahi's ability to make, and I understand, given the allegations and the risk assessment, that the state may have met its burden. The challenge with Mr. Hulahi is he is working with in an adult guardianship proceeding outside of D15. We've had a hard time getting a hold of his adult guardian. I actually got to work with Mr. Hulahi in that battery case. Some of the challenges that he faced in working with her were present in those cases, leading to the FTA, meaning that he was on a hold out of that court and not appearing in the same way through the system. The challenge for Mr. Hulahi is that there's not a place that he can go here now. Eddie was a place that he was assaulted at. CARES, as the campus reflected, had him on a 30-day sit out. This will extend it again. Record Street is not a safe place for him. We do know that he does have a partner, Miss Wilkes, Wilks, who lives in California, and he could stay there. He is expecting as a father. Unfortunately, we weren't able to get a hold of her. Given the guardianship, I would ask that this court consider doing in the alternative based on the risk assessment and the PC sheet, imposing a monetary bail, but providing an alternate if if the adult guardian is able to find appropriate living with confirmed mental health services through SCR, supportive life services through SCR, which is Sierra Regional Center, then Mr. Hulahi could be released to that appropriate placement with services in place as confirmed through the guardian. Absent that, I'd submit.
Okay, so I didn't see that in the PC sheet. So who is the guardian?
I'm gonna have to
Storage.
go ahead.
My public guardian's name is Lisa Storch.
He's had
How do you
three.
spell-
LIAS Lisa Storch. I forgot. It's Lisa Storch.
Court's indulgence, one moment. It's Lisa, Lisa, traditional spelling, and then Shortis, which is Schiotis. And in November of this year, we were working with her to try and get him established with Sierra Regional Center for Intellectual Disability and Daily Living Issues with a complex history pending and evaluations that needed to be completed at the time. I don't disagree with the state that the PC allegations are alarming, but they are just that. And there are systems in place. I don't know why Mr. Hulicki is continuing to not get services, but the place to treat him is never the jail. So but I understand incapacitation to increase the safety of the community. I would just ask that in the alternative, were we to get those systems in place that are better suited to Mr. Hulicki and the community, that we be allowed to release him OR to that process.
Okay, last name is Schiotis.
Yes, and she's with the case manager with the public guardian's office.
All right, so I'm gonna set his bail at $10,000, no 10% cash option. However, in the alternative, if Lisa Schiotis, the case manager, can verify that he has a place to live, then he will be transported to that place. And you've indicated that may be Sierra Regional Center?
They're
Or
not a
they just-
live-in facility, but they sometimes work
Right.
with, yeah. Yes, Your Honor, I'm sorry.
Yeah, and he's currently being treated by them?
He was supposed to be treated upon release. He wasn't supposed to be released until the evaluation and the treatment services were in place, but looking at the PC sheet, it appears that somehow that did happen. So I don't know what is happening, actually, Your Honor.
Okay, fair enough. All right. So to make sure I'm clear about this, in the alternative, if Lisa, the case manager for the public guardian's office, can verify that he has a place to live, and this would be in Washoe County, correct?
Yes, it would have to be
Okay.
there.
All right, so then I authorize a direct transport to that facility.
Thank you, Your Honor.
All right. In the meantime, you must stay away from Bradley Ross. Looks like you, at least according to the PC sheet, it's been more than one confrontation. You shall not possess firearms or weapons. You'll be subject to pretrial services supervision. All right. So if they can find an alternative place, you could be released to reside there.
Thank
If you
you.
need help on that, let me know. All right.
Oh, no.
Next is Raymond,
I know, but I have a place in Colorado.
Seveier.
But you can't go there until this is done.
Okay, stay ready to proceed.
Yes, Your Honor. So we are asking for $7,500 bail, pretrial supervision and no contact. Sorry, I thought I had the exact address of the business. It is, I don't. I apologize, Your Honor. I guess no
I
contact
didn't
with
see
the,
it in the PC sheet. Do you have it? It's
I-
basically
I-
set forth-
I don't. I just have it references East 4th Street and 6th Street.
Right,
So
right.
I guess I would ask for no contact with that corner.
All right.
The defendant has criminal history going back to 20 teens, some of it out of state, including South Dakota and California. However, most recently, the defendant has had a pretty continuous string of arrests. Starting in 2025, he had a misdemeanor conviction for trespass.
Your Honor, I'm sorry. Can we just, sorry, Mr. DA, but Mr. Reichenberg, can we please use pronouns that reflect female identifying?
Yes, no problem.
Thank you.
So starting in 25, she had a trespass in a municipal court, trespass, conviction obstructing and trespass. another trespass. Those were in Reno Municipal Court and Sparks Municipal Court. 2024, she had a misdemeanor conviction for trespass in Reno Municipal Court, another trespass in Sparks Municipal Court, another trespass in Reno, misdemeanor conviction for battery in Reno Municipal Court, misdemeanor conviction for trespass in Reno Municipal Court. Then in 23, she had failure to appear arrest, a failure to appear arrest, misdemeanor conviction for battery and destruction of property, failure to appear arrest, and misdemeanor conviction for vagrancy. Again, fairly similar type misdemeanor level conduct going back. However, again, just the volume of arrests and convictions over the last 3 years in the state's view indicates that she is a risk to continue criminal conduct in the community, and of the sorts of property and type crimes, and
Okay.
believe that bail is appropriate. Thank you.
All right, understood. We have a response?
Your Honor, it's another case where the state has made the Valdez Jimenez clear and convincing level, I believe, based on the 15 and the prior criminal history, recent as it is. The challenge that I have is that for Trina, the challenge is when I see that she was at the reporting party for a battery. It is my understanding that it was identity based, and then somehow the response was just to leave, and in the leaving and feeling abandoned, there was an act of violence. Do I think that it's the appropriate response to throw a rock at a building? No. Do I think that when we look at the taxpayer money for $109 to be in PC because we don't have an appropriate position for transitioning individuals, so it's going to cost more to keep her here? I don't think that's a great use of taxpayer money. And so when we talk about safety, some of that is the financial safety and the safety of our underrepresented communities. I don't have an argument. We've tried to Dorita, who is Miss Severia's sister, unable to complete that. She does report that she has addresses to stay at, would not be unhoused on the streets, but I can't report them as confirmed. I just think that all of the history that I see is low level, status-based, indigency-based, homelessness-based events like trespassing or a destruction of property or trespassing again. And so I don't have a real argument other than the system putting a person like Trina in custody is not going to make anyone safer, including her or the community that are going to have to pay for that increased incarceration for her.
All right. There's no question based on the PC sheet and her risk assessment that she is a risk to the community. Bail will be set at $5,000. No contact with the corner of 4th and 6th Street. Subject to testing, shall not possess firearms or weapons. Subject to pretrial services supervision. All right. Given her risk or her risk assessment, she's not a good candidate for release. All right.
Thank you.
Next is Bart Mettler. We ready to proceed?
We are,
Mr.
Your
Bart
Honor.
Mettler.
Yes, Your Honor. So with Mr. Bart Mettler, we are asking for $15,000 pretrial supervision, no weapons, and no contact with the address. I believe it's 65 Spark Street, and Miles Major. We would also ask for no contact with Lazira Moore. So concerning above and beyond just the concerning facts of this case and the fact the defendant handed a 12-year-old a gun, is that the defendant, while a fairly young man, has an apparent inability to take care of business and appear at court. He has 2 citations out of Reno Municipal Court. They are for traffic, but it appears even on those small matters. One is that failure to appear warrant status, and the other is that a warrant for failure to comply. And so it appears even on these minor things, he has been unable to appear and take care of business. I also show an arrest for open container of alcohol from 2023. I don't show a disposition for that. I couldn't find that case on Reno Municipal Court website. But again, concerning facts, just again, providing the firearm to such a young person, and as far as the likelihood of conviction, the defendant admitted he knew that this was wrong, even having the gun concealed as it were. And so, in the state's view, this is an individual who's not going to show up and take care of business here, and is a risk to the community with this type of poor decision making. And with that, I would submit it.
All right, do we have a response?
Yes, Your Honor, assuming, which Valdez Jimenez does, that bail in a monetary amount is inappropriate unless it is proven necessary. I don't believe the state has made that proof again today. We have a score of 7 on the NPRA, and looking at that and reviewing it, it appeared that the score was 7 after the residency and phone number was confirmed. But when I did the math, it dropped it down to a 5, which puts him just 1 point above the low range. We were able to speak with collateral resource who said that the address of that River Rock apartment 118 is appropriate and correct, that he is working for Tesla, has been there over 2 years, confirmed that telephone number ending 2149. It appears that on the Reno Municipal Court case, the issues were for non-payment. We don't want to certainly allow people not to participate in their payment of fines, but that is a issue separate and apart from, for example, complying with a domestic violence class in those cases. Given that medium, which I believe should be the lowest medium range on the NPRA, as well as the working in the confirmed address, I don't believe that the state has shown by clear and convincing evidence that bail is necessary, which is the showing that they must make. Separate and apart, in looking at the PC sheet, as I know this court has read, it does appear that he was participatory. Mr. Bartmetter made statements to law enforcement, which the state referenced in saying why he should be held on bail. But I think cut the opposite way. He said, yeah, it's there. Here it is. Here's what happened. He was participatory and cooperative with law enforcement officers, which suggests that when this court puts in restrictions, he can be cooperative and follow those restrictions. Therefore, we would ask for an OR release with the testing, with the checking in with pretrial services, certainly with the stay away order, but let him get back to work, force him to get back to work. It is a felony. There are fines associated at the best of times. Let him continue to be a resident in the community and pay taxes. I believe that that is the appropriate way. Perhaps there are things down the line that he can do, but assuming conviction, I don't think we get there on the likelihood of conviction until the state has to turn on other issues. And if so, I don't think that is clear and convincing evidence for monetary. On that, I'd submit.
Right. You said you were able to verify his address at 10 River Rock as well as his employment?
Yes, sir. Yes, Your Honor.
All right. So
And that was that was through his Aunt Dory, who's a local member of the community.
Okay, well, it did indicate in the court services that reference did call back eventually and verified his employment information. All right. All right, so I'm gonna set his bail at $5,000, no contact with 65 Park Street, Miles Major. And it looks like his cousin, Mr. Moore, will be subject to testing. Shall not possess firearms or weapons. He must reside at River, excuse me. Just had that. Looks like 110 River Rock. He'll be subject to pretrial services, supervision and monitoring. All right.
And Your Honor, I believe
Is
CCW is a C felony, so is the 10% option available?
Yes, I'm not imposing a no 10% option.
Thank you.
He'll have the 10% option. All
Thank
right,
you,
you
Honor.
need to stay away from that. If you're able to post, you better stay away from 65 Park Street. We would be right back here. All right?
Thank you, Your Honor.
All right, next is Melvin Ballard. Like we have two for him. All right, so this was a pretty substantial PC sheet. I was still able to get through it. Is the state ready to proceed?
Yes, Your Honor. So, Your Honor, in this case, we are asking for $300,000 bondable only bail. I know that there's two PC sheets. I believe that it's likely that we will file this as one case, and so if the court would like to split that 300,000 as it sees fit across these two PC sheets, we'd have no objection to that. We'd also have asked that he have no contact with the victim in this case, Miss, and no weapons, a GPS house arrest, and stay in Northern Nevada. We'd also ask that he have no contact with any minors. The defendant has criminal history, although he's a young man. His first arrest was for carrying concealed in Oakland that looks like it was ultimately dismissed in 2023. Then he had a felony conviction for evading a peace officer in Stockton, California in 2024, as well as a felony conviction for robbery in Oakland in 2024. I would note the PC sheet references other underage that through the contacts through the phone that the victim in this particular case, it's referenced in the PC sheet, is not his only victim who appears to be a minor based on the communications, who are his victims of this sex trafficking. Again, also concerningly is that the allegations indicate, one, just a lack of ties to this community. It appears that he was here with this particular victim given her apparent ties to this community. And again, with the undercover operation, the negotiations or the discussion were about him taking who we believe to be another individual to pimp and pander to the state of California. So this is a defendant who's got at a young age already has very concerning criminal history. This crime is obviously extremely concerning for the country, for the community, both here and in California, with what is apparently more than one minor that he is pimping and pandering. The firearm is also concerning given the fact that he so recently had those felony convictions in California. And so in the state's view, this defendant is absolutely a risk to the community, risk not to appear given his lack of ties to the community and the serious charges he's facing here, a risk to continue this criminal conduct. And we believe that, again, that high monetary bail, I think, in essence, a detention
All
order.
right, I understand. I understand. I mean, obviously I read through both BC sheets. All right, do we have a response?
Sure, Your Honor. I don't believe that the concerning nature of the allegations by itself is clear and convincing evidence. There is a less restrictive means. That is a GPS tracking monitoring system in those prior cases, which are recent, that the state mentioned. I didn't see any reference to failure to appear, failure to comply, failure to do his duty to the court. Based on that, we did reach out to his mother, Monica, who lives in San Jose. We were able to confirm an address. It is in San Jose. We were able to confirm employment in San Jose that he would go back to. His mom confirmed that she would be able to transport him back and forth. Given that all of that is going on, the GPS mitigates both the risk of failure to appear, and there are other means of ensuring that he's not engaging in contact, like those statutory orders that restrict communication. You could, I believe that the state would have taken his cell phone through that Celebrate report referenced in the PCs. So contact with other folk, he could have his phone reviewed by pretrial services. That is a challenge now, and I recognize that. But there are means of ensuring his compliance without setting a detention order. If a detention order is necessary, the statutory mechanism always exists for the legislature to write that in place. So there it is a bailable offense. And I want to point out that it's a 7 on that risk assessment. And that risk assessment is the socially validated tool that this court is to use in beginning a prima facie review of the evidence.
All right. So, man, I'm not going to go through the entire piece sheet, but it's evident that he encouraged and directed this individual, the victim, to engage in prostitution. And there was a lot of communications between him and her. And then the detectives then set up another fake individual, which he met at Comfort Inn and Suites, to engage her in prostitution under his control. So absolutely under no circumstances is this gentleman to be out in his community, especially when he's from San Jose, doesn't have any ties to this community. So his bail is going to be set at $150,000 each case, no 10% cash option, no contact with Chloe Sims. She's going to be subject to residential confinement, fitted before release. Shall not possess firearms or weapons, must stay in Washoe County, be subject to RJC monitoring, pretrial services supervision. All right.
And Your Honor, can the record please have KS? I believe that that's required by statute due to the age of the AV.
Right, understood. KS, what it's going to be, KGS. All right, next is, looks like Angelina Hurt, followed by Michaela Meyer. All right, again, I've reviewed the PC sheet on this case. Does the state want to proceed?
Yes, Your Honor. So in this case, we are asking for $6,000 bail. This defendant appears to have had an issue with alcohol for a couple years now. Although she is 22 years old, she has a misdemeanor conviction for possession of liquor under 21 and false reporting in Arizona. And then here we have this extremely concerning situation with the crash with the child in the vehicle. And so based upon those facts, understand she has, again, well, I'd say a relative lack of ties to the community given that Arizona case. We'd also asked for either pretrial supervision or some sort of supervision that includes alcohol monitoring, given that she's looking at her second conviction at a relatively young age for alcohol-related offenses. And with that, I would submit it.
So before, I just wanted to confirm. The name of the child was not mentioned in this case.
And Your Honor, I plan to address that in my reply.
Okay, fair enough, because I wanted to know if it was her child or another person's child. All right, you can proceed.
Thank you, Your Honor. Your Honor, one prior misdemeanor conviction does not establish clearly and convincingly that there's no way to keep her in the community other than bail. That is like clearly not what is established in Valdez Jimenez. And this is in this case, Miss Hurt scores a 7, which again is that middle range. I believe that Judge Pearson has told us 92% of those who fall in the middle range, according to that statistic.
Liz Meyer, I'm gonna OR her.
Okay, thank you. She, the child is with
Before,
state
hold on,
mother. She's
before we
compliant.
go any further, hold on. My intent is to OR her, but I need some additional facts. All right. You said so I'm sorry to cut you off, but who is the child? And what's the relationship?
The child is her son. She is in communication with CPS. The social worker's last name is Esty. Her son has been staying at her mom's residence. Her mom begins working Wednesday. And CPS is putting, Health and Human Services, formerly known as CPS, is putting in a present danger plan with Miss Hurt that needs to begin on Monday, on Monday, so that her son can stay out of the system. We have confirmed with CPS worker that that is true. She has an address in the area at Sierra Summit Boulevard.
Okay. She
And-
doesn't reside 4131, looks like Boots Court.
That's my mom's address.
That's her mom's address. She can stay there, but if CPS needs her to stay elsewhere for her son to be present, we just wanted to provide an alternate address because her biggest concern is being able to provide care for her son.
I understand. What was the address where she can reside?
She could stay with friend Kalina at 14001 Summit Sierra Boulevard. Which is, and then an apartment number. What we would ask is that she stay at a residence approved by CPS through the present danger plan.
You said the child is with her mother?
Yes,
With
Judge,
with her mother, correct. All right.
who is a
And that
resident.
was the address. Yeah, and that was the address I listed, 413 Boots Court.
Yes, sir.
All right. So I understand the states, the facts are concerning. And there is obviously a substance abuse problem, but nevertheless, she's gonna be OR'd release, but it's gonna be subject to several conditions. No contact with 4131 Boots Court where the child is staying or her son unless CPS consents. All right, she must comply with all CPS requirements, including this present danger plan. All right, she'll be subject to testing. I'm having her also have residential confinement before release. All right, she'll also have to reside at a residence approved by CPS. Or the set residence that's been provided to me, 14001 Summit Sierra Boulevard. She'll be subject to monitoring by pretrial services. All right, you're getting a second chance here, miss. You understand?
Yes, thank you, Your Honor.
All right. I don't want to see you back here. All right?
Yes, Your Honor.
All right, next individual is Michaela Meyer. He's the co-defendant with Mr. Burr. So is the state ready to proceed at same facts as Mr. Burr's case?
Your Honor, same PC sheet. The facts are much different in terms of any involvement from that hotel space.
I understand, and I read the PC sheet, but she was if I understand it, she drove the car.
To pick up a moped.
Understood.
Your Honor,
All
with, oh, sorry.
Go ahead.
So with Ms. Meyer, I show she scores a 6. I could not find any prior criminal history for her. And understanding that she drove the individuals there, we are not objecting to an OR. However, we would ask that there be no contact between her and the other co-defendants who, I believe Madam Clerk has their information for the no contact order. I listed it previously with Mr. Burr's case, obviously with Mr. Burr substituted in the no contact order for Miss Meyer, and pretrial supervision to ensure that she attends future and no weapons, as well as no contact with the victim. Thank you.
All right, so Ms. Meyer, I had her for an OR release too. All right. So
Wonderful.
I just disagree with you that other than maybe one paragraph in this entire PC sheet. All right, the fact's the same. I just don't want it to be repeated again because I'm familiar with it. All right, so she is going to be OR'd. No contact with Patrick Moore, Mr. Burr, Lillian De Silva, Anthony Johnson, Jacob Galindo Cloud, Justin Moore, and Justin Moore shall not possess firearms or weapons, should be subject to monitoring, pretrial services supervision. All right. Make sure you do not contact those individuals, all right, miss, or you'll be right back here.
Yes, Your Honor.
If they call.
Yeah, so her arraignment date is February 25th, 2026.
They're gonna let you out.
And sorry, Ernie, did you mention Patrick Moore, the victim? I might have missed that.
He
Yes, I
did.
did.
Okay, sorry. Thank you. Thank you.
Court's indulgence, just one moment.
All right. All right.
Thank you so much.
Now, the next individual is Freddie Young. All right. State ready to proceed.
Yes, Your Honor. So in this case, we're asking for $15,000 bail. We're looking at a category C here, so I believe that would be subject to the 10%. Pretrial services supervision, no contact with Palace Jewelry, and no weapons. The defendant has criminal history going back to 2006, concerningly 2008 felony conviction for attempted robbery in Sacramento. 2014 looks like felony conviction for violating parole in Sacramento. 2015 felony conviction for possession of marijuana for sale in Sacramento. A 2017 felony conviction for robbery in Sacramento. He had a misdemeanor conviction for domestic violence in 22 in Sacramento. And then in 24, he appears to have come to this area. He had a felony conviction for home invasion here in the 2nd. And so given the sort of brazenness of these allegations, as well as the lengthy prior convictions for felonies, we believe he's a risk to continue this conduct and therefore a risk to the community. And with that, I would submit it.
Okay, we have a response.
Thank you, Your Honor. Your Honor, I don't believe that the NPRA number is appropriate. We were able to speak with Mr. Young's brother, Dre. Dre was able to confirm the telephone number for Mr. Young. dropping it down to 9 points, and an address for Mr. Young on Manhattan Street in Reno, dropping it down another 2 points, which puts it in the medium range. He also was able to confirm that Mr. Young has been working, putting it at around 6 points, I believe. With that in mind, and with the alternate means available, the stay away order from the Palace Jewelry, certainly, as well as check-in. There's no indication of this being connected to drug or alcohol. Certainly, he could do a check-in. In the alternative, if the criminal history, I did not see or hear and note any failures to appear, but if those are present, GPS monitoring is available, but a monetary bail is again presumed not appropriate unless shown it is necessary because nothing else exists. In this case, GPS, it is an appropriate way if there's been prior issues, but I didn't see those. Given that the 10 drops down to a 6, I believe it is appropriate to OR. In the alternative, I would ask that this court impose the more modest $5,000 or 10% cash option.
All right, so you able to verify, because they were not able to verify any of his information because he didn't give a reference. So were you able to verify his address?
Yep, it took a couple of numbers, but we were finally able to get a hold of his brother Dre. And the address is 1401 Manhattan Street, Reno, Nevada.
All right, is there a unit number?
I don't believe so, Your Honor. Is there a unit number? 4.
Apartment number 4?
Yes, Your Honor.
All right,
And Your Honor, does this court need the terminal 4 numbers of the cell phone confirmed?
no.
Okay, thank you.
The other thing I wanted to confirm with the state, is he currently on probation?
Yes.
Yes, I believe he would be by the timing.
Right. All right. So I'm gonna set his bail at $7,500, 10% cash option. All right, no contact with the Palace Jewelry or Ben, Derian, given the other count, shall not possess firearms, must reside at 1401 Manhattan Street, apartment 4, Reno, Nevada. He'll be subject to monitoring and pretrial supervision. All right. 10% cash option will give him an opportunity to bail, but it'll be subject to those conditions.
Thank you, Your Honor.
All right, Daniel Ibarra. All right, stay ready to proceed.
Yes, Your Honor. So in this case, we are asking for $100,000 bail. The defendant has criminal history, some of it fairly remote, but apparent that he has had issues with controlled substances for quite some time, and that his first conviction was in 2002 for a possession of drug paraphernalia in Sparks Municipal Court. He also had a possession of drug paraphernalia case in 2015 where he was convicted. He had a failure to appear arrest in 2016, and then another possession of drug paraphernalia conviction. This is a concerning case given just the high amount of controlled substances that he was apparently bringing into this community. He'd indicated that travel to California, which was confirmed by law enforcement. But again, this is an extremely high amount of methamphetamine that appears to be bound for this community given his ties and residence here. So in that regard, This is an individual who, while apparently had a period of sobriety or at least not contact with law enforcement, has had issues with controlled substances for over 20 years now, and was bringing an extremely large amount that poses an extreme risk to this community. And so therefore, we believe that bail is appropriate, pretrial supervision, testing for controlled substances, and GPS house arrest monitoring. Thank you.
All right, do we have a response?
Yes, Your Honor. Again, we have a 6 here, which is the validated tool, which suggests that he's a medium risk, which means 92% of the time he's going to follow the orders and show up. That failure to appear was 10 years old, which is why it's not reflected in the validated tool. We were able to reach out to Mr. Martin Ibarra, who is Mr. Ibarra's father. He was able to confirm that Mr. Ibarra does have, Mr. Gutierrez Ibarra, Daniel, does have a telephone number and confirm that telephone number, which takes another point off the NPRA, and confirms an address for him in the area, which takes another 2 points down. That makes him a low risk on the 4. Given that we've been able to confirm that, we would ask this court do testing for substances, allow him to live in the community with a GPS, and not impose a monetary bail, which is preferred against. Mr. Ibarra has confirmed again that there is transport other than the impounded car. And Mr. Gutierrez Ibarra has confirmed that he'd be willing to do testing at the order of the court. Therefore, what he would like to do is be able to be released to work and to continue complying with those testing requirements. And I believe that the NPRA suggests that that is the appropriate order for the court, given the other means available than monetary bail. It does appear that there's been no intersection with the criminal legal system in a decade. Best predictor of future behavior is past behavior.
Well, not with the amount of drugs that he had a substantial amount. His bail is going to be set at $100,000 residential confinement, fitted before release. He'll be subject to testing, be subject to monitoring, pretrial services supervision. He's able to post. He must reside at 1015 Tyler Way. It's indicated in court assessment notes. All right.
Thank you, Your Honor.
All right. Next is Martin Correa Flores, it looks like. And was the state able to reach out on this case? To the victim?
I don't have
Or
any
the
notes
brother?
that we were, Your Honor, but there appears to be someone on the call. I'm not sure who that is or how they're related.
Do we have somebody? Okay, all right, you wanna, is he in? All right. So we understand somebody's has called in on this case. Could you please identify yourself? Is it Martin?
Yes.
All right. And then, are you one of the brothers?
Yeah, that's my twin brother was Anthony Correa. I am Mark. I am.
Right. No, but we have somebody I thought that is in. You need to unmute and identify yourself for the court, please. Any luck? You know if it's Anthony?
It probably could be, or my. Okay.
Pardon me?
Your Honor, I believe it would have to be someone to whom the district attorney's office provided the Zoom link because it's not public. And we didn't-
I would assume the same thing, but that's why I ask, given this case. I mean, we've got the mother, got cousins,
No.
got the brother.
Your Honor, we now have a visual, and I believe that Mr. Correa confirms that is his spouse.
Okay, who is it?
His wife.
Okay, got it. All right,
And Your Honor, I believe that
So-
that would be Vanessa Correa for the record. Is that correct, madam?
Yeah, Vanessa Dominguez.
Vanessa Dominguez.
so we didn't hear a response from you, miss. Would you please identify yourself for the record? You're muted. All right. Well, hopefully you'll be able to connect the audio, miss. Are you able to? Can you hear us at least, miss? Okay. So before we proceed with the state, I just need Ms. Meyer to verify. So based on my, are we able to verify any of his information?
We
Ms.
were able to
Meyer?
verify all of it, Your Honor.
All right, so he lives at 665 Angela Street in Fernley, correct?
Correct, Your Honor.
And let me just check one other thing here. In reviewing the PC sheet, that's not the address where this incident occurred, correct?
Correct.
All right.
Where are you going?
And does the state or Ms. Meyer have the address where the incident occurred? Because I was not able to locate it.
That's my old.
I believe it's 117 Heidel Road, Heidel.
That is correct.
All right, that's right. All right, so I think he's a candidate for an OR release, so we can really cut to the chase on this matter. He'll have to stay away from the named victim, Anthony Carrillo, 117 Heidel Road. He'll be subject to testing. He must reside at 665 Angela Court in Fernley. Should not possess firearms or weapons. He'll be subject to monitoring, pretrial services, supervision. Are there any other conditions the state wanted to impose?
No, Your Honor. For the record, we were going to ask for bail, and part of that's based on the fact that he's got the pending DUI, where looks like pretrial services asked for him, as appears to me, asked for him to be revoked on that case, or asked for modified bail. I'm not sure if that was addressed already or if that is going to be addressed sometime soon. But I have no further conditions.
All right, so I'm gonna have one other requirement. He's gonna be subject to residential confinement and fitted before release. Other than that, he's gonna be OR'd, given his risk assessment. Because he's gonna be subject to testing, RJC monitoring and pretrial services supervision, I think that'll be enough. At least on this case. And I'll have no contact with the victim as well as the address. Did you want to add anything, Ms. Meyer?
I would just ask this court to consider allowing 24 hours, the difference after release to get fitted for the ankle monitor. The difference financially can mean a lot, and Mr. Correa is working as a roofer and a mechanic. It is tight times right now, and so that I think it's the difference of $395 versus $90. That difference can make all the difference in the world. I understand that this is an OR, but even with that pending case, he's only a 5. But I'd submit, Your Honor.
No, he's gotta be fitted before release, given the pending case.
Thank
All
you.
right, all right, next is,
Oh, and his arraignment, Judge.
oh, and Remy, same one, same date.
Yeah, February.
Okay, I'm sorry, 2/25/26, 9 AM.
Ankle monitor.
All right, next person is Clifton Despani or Despain?
Disdain.
Okay,
Your Honor, could we continue this 24 hours? Mr. Despain is not feeling well enough to speak with us.
okay. Well, no, I've already signed off on his public defender application. He didn't have one. So we can at least put that on the record when he comes back tomorrow, but the public defender will be representing him.
Thank you so much, Your Honor.
All right, next is gonna be Ms. Hernandez. Okay. Is the state ready to proceed?
Yes, Your Honor. First, I would note at the outset that
Her name is Ramirez.
well, yeah, I do believe she has the hyphenated name, but I would note that she I don't show that she has any criminal history. However, concerningly with this case is this is obviously an extremely vulnerable member of our community. It's a high dollar amount and activity that had gone on for quite some period of time. And so despite the no criminal history and the NPRA score, we are asking for bail in the amount of $10,000 as well as pretrial supervision and no contact with Mr. Dodd. And with that, I would submit it, Your Honor.
Hey, Ms. Meyer.
Thank you, Your Honor. Your Honor, this is Ms. Hernandez's first lifetime arrest. The purpose of bail is obviously not to punish, but to ensure compliance and safety of the community while a case is pending with the presumption of innocence. In this matter, we have a 40-year-old mother arrested for the very first time. There was no crime of physical violence, not to say that financial exploitation is not a significant crime. However, when it comes to risk of the community, that position that makes it a crime is very limited. In this case, we were able to speak with her husband, Gabriel Hernandez, who confirmed her address at that 2630 Hiko or Hiko Avenue address. She is a mother to one young son there. That son is on the autism spectrum and carries that autism spectrum disorder. Additionally, Ms. Hernandez is receiving hospice care in the home with management both for skills of daily living and some of the palliative care. The jail can't provide those, and so some of the concerns about it not being unduly punishment, it is painful for her to be here without any of the access to palliative care. Given that there could be GPS monitoring, there could be a payment plan, there could be check-ins, there could be testing for drugs. There are numerous systems when you have someone who scores a 3 and is not displaying any signs of intoxication or violence to others. It is a serious crime that is alleged, but it is limited in scope and doesn't pose the broader because it depended on that trust. I believe that under that, Valdez-Jimenez requires this court, even in the spite of the state's argument, to put a non-monetary bail condition in place. Absent questions from the court, I'd submit.
All right. I have a question for the state. I didn't see anything in the risk assessment, just to confirm, because sometimes it has a 0 on substance abuse. But the defendant will say in the notes that they're interested in substance abuse treatment. Any history of substance abuse?
No, Your Honor.
Okay. All right. I believe some amount of bail is appropriate in this case, given the amount that we are talking about. It's gonna be $5,000, 10% cash option. No contact with the named victim, Harold Dodd, or his residence. Should be subject to residential confinement, fitted before release. Other conditions would be she must reside at 2360 HIKO Avenue, should be subject to monitoring and pretrial services supervision. All right? Given a
Thank
risk
you, Your Honor.
assessment, she'll be out if she's able to post $500. It'll be subject to those conditions. All right?
Thank you,
So
Your Honor.
I'm showing Ms. Hernandez as to be the last individual. Is that accurate?
Yep, we're getting kicked out, Your Honor.
Okay, you have a good day. I'll see you tomorrow.